Let me share my screen with you all. Okay, so hopefully you guys can all see this. Oops, 1 second. So this is my contact information. If any of you need to contact me afterwards, you can always feel free to contact me at ys@surrogatesteps.com, or you can also reach me via phone at 607-229-6503. So we'll first start by setting the stage and talk a little bit about assisted reproductive technology and surrogacy. So first, it's important to understand who this really affects. So it's couples and individuals, mostly including the infertility community and the LGBT community. And it's a way that we can build and grow our families through assisted reproductive technology. And that can include egg donation, sperm donation, embryo donation, and also surrogacy. And in regards to infertility, the American Society of Reproductive Medicine defines infertility as a disease of the male or female reproductive tract which prevents the conception of a child or the ability to carry a pregnancy to delivery. And at this time, it is estimated that infertility affects approximately 12% of couples of childbearing age. And every state has their own laws when it comes to assisted reproductive technology and surrogacy law. So it is very important that individuals growing their families through assisted reproductive technology seek the advice from an attorney specializing in this particular field, because it's a very specialized field for surrogacy law. So we'll start from the beginning, really, by understanding what is a surrogate. A surrogate is a woman who agrees to become pregnant through assisted reproductive technology, such as in vitro fertilization, and she carries a child for the intended parents. And there are two types of surrogacy arrangements. There is a traditional surrogacy and a gestational surrogacy. Traditional surrogacy involves a surrogate who agrees to carry the child for another couple using their own eggs. Therefore, the child born is actually genetically related to her. And you can imagine that this is actually a very risky process, both emotionally as well as legally. Emotionally, because the woman might have a difficult time giving up a baby that she's genetically related to. And legally speaking, it can be very complicated because the law might most likely recognize her as the legal mother, because she's both the genetic mother as well as she's the person who gave birth to that child. And what this means is that the intended mother might have to actually adopt her own child. And then you have gestational surrogacy. So in contrast, a gestational surrogate, also referred to as a gestational carrier, is a woman who agrees to become pregnant for the intended parents by means of assisted reproductive technology, where the eggs of the intended mother or an egg donor is going to be used. So therefore, the gestational carrier is not genetically related to the child that she is conceiving. Now, the current New York law has a lot of restrictions on surrogacy, partly of which it does not allow for compensated surrogacy. So a surrogate can be a compensated surrogate where she's receiving certain payments throughout the surrogacy pregnancy for the risks that she's taking, or she can also be a compassionate carrier where there's no payment involved. And currently, A compensated surrogacy is not allowed in New York. And in addition to that, any contract between the surrogate and the intended parents is considered unenforceable as a matter of public policy, and it's even punishable by a fine. So the Child Parent Security Act, is the new surrogacy law in New York that's going to take effect February 15th of 2021. And it really took New York almost a decade to pass this bill. It was first introduced in 2013, and I have a picture here of Senator Brad Hoylman, who initially introduced this bill, and he was sponsoring this bill. Him and his husband ended up having to go all the way to California to do gestational surrogacy in California so that they can compensate their surrogate because of the way New York law currently is. So he initially introduced it. Like I said, it took approximately a decade until finally it passed the legislature through the governor's budget. And there are still attempts really to try to make some changes to this bill to make it even more surrogate friendly. But these changes are just being contemplated now, being introduced, and we don't know if they will be approved before this new law is actually going to go into effect February 15th. So genetic surrogacy, the new law only applies to gestational surrogacy, where the surrogate is not related to the child that she's carrying. So it does not apply to traditional surrogacy where there is a genetic connection. Any contract relating to genetic surrogacy will continue to be void and unenforceable. And compensation is a pretty big change, obviously, with this new law, is in that the new law does now allow for compensation to the surrogate. Compensation must be placed in an escrow account if you are in fact compensating your carrier, and that escrow account has to be held by an escrow agent licensed in New York or by a surrogacy agency also licensed in New York. And funds for the surrogate have to be placed in that escrow before she starts her medication cycle. And the final payment must be made no later than 8 weeks post the delivery. And it's very important to understand here that the compensation that the parents are paying the surrogate is for the medical risks that she's taking and the physical discomfort, the inconvenience, and the responsibilities that she's undertaking in connection with the surrogacy arrangement. So no one is paying her to actually have a baby for them. No one is obviously buying a baby. Her compensation is for the risk and inconvenience that she's undergoing. So just to give you an example, the payment that she's receiving cannot be conditioned on in any way on the quality of the embryos or on how good the embryos are, or if a child being born healthy or not. There is no guarantees at all. So regardless of what happens, we are not buying a human. Her payments are again just for the risk and the inconvenience that she's undergoing. Okay, so I'm going to try to take a break right here just to see if anybody so far has any questions. And again, I'm sorry, I'm new to Facebook Live. Let me see. Okay, I'm just going to read through some of your comments, see what the questions are. Okay, I hope you guys can see. Are you guys able to see the slides? Are the images not showing? Okay, good, they're showing. Okay, all right. So does anybody have any questions so far? If not, I'll continue. Thank you so much, you guys. All right, awesome. It's my first time doing Facebook Live, so again, I appreciate it. I'm glad you guys can see everything. Okay, so we'll go back to the power slides, okay? All right. So here we go. I think I have to share my screen again. Oh no, okay, we're good.
Hey, Yifat, can you start from the beginning? Because people couldn't see from the. So if we could start from the beginning, that would be great.
Oh, really? I'm sorry about that.
Yeah,
okay, can you guys see my slides though? Can you guys see the slides?
When you transfer to that mode, we can no longer see your slides.
Okay.
So whatever you,
in this mode, can you see the slides?
Yeah, we can see it now.
Okay, so I will just do it in that mode. Sorry, guys. All right, so here we go. We'll start fresh. Were you guys able to hear me though?
We can hear you and see the slides now. We can't see your face, but we can hear your voice just fine.
Okay, all right. So
I guess that's the most important stuff. We can see the slides, hear your voice, and I think it's good.
Okay, good. I'm glad you guys can at least see that. Thank you for that. So I'm going to try again to just stop every once in a while and take any questions that any of you might have. Like I said from the beginning, so my name is Yifat Shaltiel. I am an attorney. I'm really excited to be with you all this evening doing this again for the first time. So thank you for your patience. And I've been a reproductive law attorney and surrogacy law attorney for over 10 years in New York. I'm also co-chair for Reproductive Health Law Committee for the Women's Bar Association of New York. And I'm the director of Surrogate Steps, a surrogacy matching agency where we match the intended parents with surrogate mothers. So again, I'll try to take your questions throughout, but if you guys, my contact information is here. If you guys need to get a hold of me afterwards at email, via my email at ys@surrogatesteps.com or 607-229-6503. So basically what we're doing today is we're just reviewing infertility and surrogacy in general. We're going to go through the different types of surrogacy arrangements. We're going to cover what the New York law is right now, so everyone has a good baseline of what the New York law is now versus what the New York law is going to be regarding surrogacy, which is going to take effect February 15th. So we'll review some of those requirements. We're not obviously going to cover absolutely everything, but we're going to touch on the main issues and requirements, okay? Okay, so here we go. So we're starting out with setting the stage regarding assisted reproductive technology and surrogacy. As I stated, this is really for couples and individuals, including the infertility community, the LGBT community, so that we can build and grow our families through assisted reproductive technology, which includes egg donation, it includes sperm donation, embryo donation, and of course, surrogacy. And in regards to infertility, the American Society for Reproductive Medicine defines infertility as the disease of the male or female reproductive tract, and it prevents the conception of a child or the ability to carry a pregnancy to delivery. Approximately 12% of couples suffer from this. And when it comes to surrogacy law, every state has their own laws, which is why it's important to consult with a reproductive law attorney who specializes in that particular area. Okay, so again, we start in the beginning with what is a surrogate, so everyone's on the same page. A surrogate is a woman who agrees to become pregnant through assisted reproductive technology, such as in vitro fertilization, and she carries that child for the intended parents. And there are two types of arrangements. There is what is called a traditional surrogacy, also known as a genetic surrogacy, or a gestational surrogacy. And in a traditional surrogacy, it involves a surrogate who agrees to carry the child for another couple, and she's using her own eggs. So what happens is the child that is born is actually genetically related to her. And I definitely have had some clients who have chosen this route before, but you can imagine that this is definitely a more risky process because it's risky emotionally and it's risky legally. Emotionally, because the woman might have a difficult time giving up a child that there's a genetic link to. And legally speaking, because the law is most likely going to be recognizing her as the legal mother, since she's both genetically related to the child and also the person who gave birth to that child. And what that means for the intended mother in a situation like that is that she might have to adopt her own child under this type of an arrangement. Okay, so in contrast, gestational surrogacy, also referred to as a gestational carrier, gestational surrogate, or gestational carrier, is a woman who agrees to become pregnant for the intended parents through assisted reproductive technology, where the eggs that are being used are either the eggs of the intended mother or the eggs from an egg donor. So therefore, the gestational surrogate or gestational carrier is never going to be genetically related. There's never going to be a genetic link between her and the conceived child. So in terms of statutory regulations, there's also what is called what we call compensated surrogacy and a compassionate carrier. And in New York, we are not allowed under the current law to compensate a carrier for being a surrogate and for the risk and for the journey that she's taking. And right now, under the current New York law, any type of contract between either compassionate or compensated surrogate is unenforceable as a matter of public policy, and it is even punishable by a fine. So it's very, at this time, not surrogate friendly. And then with the new law, which is the Child Parent Security Act, this is all going to change, going into effect February 15th of this year. So it took New York almost a decade to pass this bill. It was initially introduced in 2013. Senator Brad Hoylman is the senator who sponsored this bill. And basically his journey with his husband is that they had their family, they expanded their family through surrogacy, but they had to go all the way to California to have a paid gestational carrier in California because the law in California is much more surrogate friendly than New York, obviously. So they were not able to do it here and they had to go all the way to California to do it. So he sponsored the bill, and the bill finally did get passed by the governor's budget. And it basically, like I said, took almost a decade to do this. And there are still some attempts to try to change this bill to actually make it even more surrogate friendly. But they have not been approved yet. So that's not in effect just yet. But they're working on trying to make it more surrogate friendly. We'll see what happens. So the new law, the new surrogacy law, is only going to apply to a gestational surrogate, to gestational surrogacy, where the surrogate is not related to the child that she's carrying. So it's not going to apply to traditional surrogacy where there is that genetic connection. And any contract relating to a genetic surrogacy is going to continue to be void and unenforceable. Okay, so like I said, we have a compensated surrogate and we have also a compassionate surrogate. So one of the big changes with the new law is that it's going to allow now for compensation to a surrogate. Compensation must be placed in an escrow account. It has to be held by an escrow agent or a surrogacy agency that is licensed in New York. And the funds for the surrogate must be placed in that escrow before she starts her medication cycle. And then the final payment must be made no later than 8 weeks after the delivery of the child. And this is where, like I said, it is very, very important to understand that the compensation that the parents are paying the surrogate is for the medical risks that she's taking the physical discomfort, the inconvenience, and the responsibilities she's undertaking in connection with the surrogacy arrangement. So no one is paying her to have a baby for them. No one is buying a baby. Her compensation is for the risks and the inconvenience that she's undergoing. So to give you an example, we cannot pay the surrogate and condition her payment based on the quality of the embryos or how good the embryos are, or if the child is born healthy. So we cannot have those kind of conditions attached to the compensation. There's no guarantees, and no one is buying a human. So again, the payment is just for the risk and inconvenience that she's undergoing. Okay, so this is where I just wanted to take a quick break and see if you guys had any questions so far. Okay, all right, no questions so far. Okay, let's see. So, where before, under the old law, we were not allowed to enter into any kind of contract between the gestational carrier and the intended parents. Now, the intended parents and the surrogate can enter into a contract known as the gestational carrier agreement. And now, under the new law, that agreement is going to be enforceable. And the new law is going to require the parents to have that contract in place and to make sure that the purpose of the contract is to make sure that really it just provides everyone with protection. Where before we could only do things like a memorandum of understanding, now the parents, the surrogate can all feel comfortable that their entire understanding, all of their agreements are now going to be in writing and that they're all going to be enforceable in court. Also, the surrogate is going to have her own attorney that is paid for by the parents, and all the attorneys involved must be licensed in New York State. So the statute does require that, but really it's not anything so new because the standard in the industry really is for the surrogate to always have her own attorney, and usually it's always paid for by the intended parents. And if the surrogate is a compassionate carrier, so she's not receiving compensation, then she still needs to have her own counsel. But in that case, if she's compassionate, then the parents are allowed, as long as she waives it, the parents don't have to pay for her counsel. So she can waive their obligation to pay for her attorney. And so this is also an interesting requirement with the new law where there's a citizenship and residency requirement. So it requires that the surrogate, if it's a New York surrogate, she has to be a U.S. citizen or a lawful permanent resident. And she had to have been a resident for at least 6 months of New York, a New York resident for at least 6 months. And at least one of the intended parents have to be a U.S. citizen or a lawful permanent resident. And they also, at least one of them, has to be a resident of New York State for at least 6 months. And so there's a lot of things that are required from the surrogate for her to be eligible. So in addition to the citizenship and residency requirement, she also has to be at least 21 years of age. And again, this is one of those requirements that it's already being followed in the industry. I've never seen a surrogate under 21 years of age, but now it's enumerated in the statute and it's required. The surrogate also has to pass the medical evaluation by the healthcare practitioner, such as a fertility clinic, relating specifically to that anticipated surrogacy pregnancy. And the new law also requires a surrogate to sign an informed consent after the medical evaluation, which indicates that she understands the risks of surrogacy, including the possibility of multiple birth, the risks of the medication that she's taking for the surrogacy, and any potential pregnancy complications or psychological risks. And again, these are things that are currently happening anyways, but now it's also being enumerated in the statute as well. So it's a protection that's there, but really up until now, we've already been following this. Okay, so insurance is a big, big topic. The new law does require the surrogate to have life insurance in place prior to starting her medication cycle, and it has to remain in place for 12 months after the pregnancy. And the life insurance coverage has to provide her with a minimum of $750,000 for the benefit of her beneficiary that she would choose. The surrogate also, if she wants, can require the intended parents to provide her with disability insurance. And if she requests this, then the parents do need to cover that as well. And if that is also what she wants, then you need to be careful because it has to be in place before she starts any type of fertility treatments or is seen by the fertility clinics. Otherwise, she might not qualify. And of course, the surrogate must have medical insurance. And this must be also in place prior to her starting the medication cycle. And it has to, again, remain in place for 12 months post the pregnancy. And again, the parents are responsible for paying her premiums of the insurance policy unless she's a compassionate carrier. If she's a compassionate carrier, then in that case, the surrogate can waive the parent's obligation to pay for that policy. But otherwise, they have to pay for that policy as well as the life insurance policy and the disability insurance policy if that is what she's requesting. So let me just take another quick break, make sure you're all okay. Okay. So the Surrogate Bill of Rights, the new law wanted to make sure that it did provide protection for the surrogate. And these are her rights that she also has to receive notice of in writing, and they are not waivable and they cannot be limited in any way. So any verbal or any written agreement that tries to limit these rights in any way, or if they try to waive these rights, that is going to be void and unenforceable as against state policy. So we cannot waive these. And I've listed them here for you. So we'll briefly discuss some of them. There's the health and welfare decision. So the surrogate has a right to make health and welfare decisions regarding herself and her body, which includes, for example, consenting to a C-section or consenting to multiple embryo transfer. There's independent legal counsel, and this is her right to an attorney both in the contract phase as well as in the parentage birth order phase. So she has to be independently represented by a New York licensed attorney in all stages of the surrogacy journey. The health insurance and medical costs, as I just covered with you guys, she has to have that in place. It has to be paid for by the intended parents unless she is a compassionate carrier, in which case she can waive the premium payments. But otherwise, it does have to be in place, and it has to be in place for up to a year after pregnancy. And it's specifically after pregnancy. So even if there's no delivery, even if there's a miscarriage, it has to be in place for 12 months, a year after pregnancy. And then there's life insurance. Again, the intended parents are responsible to cover her life insurance in the minimum amount of $750,000. Counseling is the surrogate's, she has a right to obtain a health insurance policy, which the intended parents pay for, that is going to cover psychological counseling for any issues resulting from her participating in the surrogacy arrangement. And termination of the contract. The surrogate can terminate the surrogacy arrangement and the agreement so long as she does that before she actually becomes pregnant. And it's actually the same with the intended parents. As long as the surrogate is not pregnant before she becomes pregnant, either the intended parents or the surrogate can terminate the agreement. Okay, parentage. So under the new law, so long as all the requirements are complied with and there's a valid gestational carrier agreement in place, the intended parents are the legal parents, and that happens automatically by operation of law. So it's as long as everything is complied with, you're going to be considered the legal parents. However, even though it's by operation of law, we do still need to go to court. We need to get a court order that recognizes that everything was complied with, and that court order will declare the parents the legal parents. Okay, so what happens if we don't comply with the new law? So if the new law is not complied with, and that could be for a lot of different reasons, whether there is no gestational care agreement in place, or if the surrogate didn't meet all the requirements, then the intended parents can still be recognized as the legal parents, but it's not going to be based on this new law. It's not going to happen automatically by operation of law. So it's going to be a longer process with the courts to get that parentage recognition. And obviously, it's going to depend on the situation as to exactly what's going to need to be done. And in some cases, that might involve an adoption or a second parent adoption. If after the intended parents enter the surrogacy agreement, and the gestational carrier agreement is properly executed, then a separation or a divorce of the intended parents is not going to affect the intended parents' rights or their duties and responsibilities that they have to the surrogate, and any obligations that might be outlined inside their gestational carrier agreement. So, for example, they're both still going to be responsible for all the agreed upon compensation to the surrogate. They will both be responsible for payments of the health insurance and life insurance. And once a child is born, they're both going to be recognized as the legal parents by operation of law, even if they no longer wish to have that child. And I just have a good example here for you regarding actress Sherri Shepherd. So Sherri Shepherd and her husband, if you guys remember, at the time they intended to conceive a child. They used an egg donor and a surrogate. And their surrogate did conceive using that egg donor. They had the child. However, they separated. And after their separation, Sherri decided that she no longer wanted to be recognized as the legal mother. And she was claiming that because there's no genetic connection and an egg donor was used, she's not the legal mother. And in that case, which happened in Pennsylvania, the court there did hold that based on intent, she is going to be the legal mother because she intended and took every step to become the mom. And it's going to be the same now in New York under the Child Parent Security Act. So beginning February 15th, it's going to be the same in situations like that. The parents will be declared parents based on intent to create their child and based on all the steps they're taking to have the child. Okay. Sorry, I'm just looking to see if you guys have any questions as I'm doing this. All right, so benefits to the parents. So this law is good. The purpose of the law is, to make New York surrogate friendly and to protect all the parties and for the law to really catch up with medical technology. And I think that it does do that. The new law does finally allow for compensated surrogacy, and it recognizes legal parentage by intent, which is very important. So if intended parents can show that they intended to have the child and took all steps necessary to have that child, like we said, even if there's no genetic connection, the law is still going to recognize them as the legal parents. And surrogacy contracts will now be enforceable. So the parents can rely when they enter into the agreement with the surrogate, and same with the surrogate, they can rely on that agreement that everything now is going to be enforceable. And it also eliminates a lot of court intervention that was previously necessary. Sometimes in the past, under the old law, we needed to either do an adoption or a second parent adoption, or it required multiple court hearings. I had one case where we had to have an entire trial, even though everyone was consenting. It's just simply what the judge wanted. And we had to go through hours of that. And now, under the new law, none of that is going to, we're no longer going to need to do all of that. It's just going to be a very simple court proceeding with most likely just one appearance, recognizing the parents as the legal parents by operation of law, so long as we can prove that we've met all the requirements under the statute. So I also wanted to review with you guys some things that a lot of my clients that it comes up a lot with my clients. It's important whenever you're working with a surrogate or you're considering a potential surrogate, before you proceed with the surrogacy journey, whether even if it's an agency or if it's self-matching, if it's a compassionate carrier, if it's like a friend or family member, there's always some things that you really need to review with your surrogate and make sure that you're all on the same page. So one of that is when it comes to potentially terminating or selectively reducing a pregnancy, is that you have to make sure the surrogate and the intended parents are in agreement with that and that everyone is on the same page. So under the new law, this is a decision that the surrogate will make, which is really the way it is mostly everywhere. So it's not just New York, but you want to make sure that this is part of the screening process, that in the beginning that you already have discussed this, that you all agree, that you have the same values in terms of termination or potentially having to reduce a pregnancy. So for example, most of my clients, they want the option to make the decision at the time. So they don't know what decision they might make if something like that arises, but they want to be able to make that decision at that time. So it's important that the surrogate is going to agree to that. So even though it's a decision that is ultimately going to be the surrogate's decision, we can still make sure that we discuss this all in advance and that we're doing proper screening and that everyone is on the same page, so we don't have to go through any other issues or potential litigation. You're also going to want to know how much contact everyone is expecting, both during the pregnancy as well as after delivery. And when it comes to post-delivery contact, in our contracts, we always like to state that it is in the discretion of the intended parents, because really, it's just going to really depend on what type of contact you develop during the surrogacy arrangement, what the relationship that you develop during the arrangement. And based on that relationship is most likely how you're going to feel after delivery. But a lot of people don't really know what they're going to want to do post-delivery. So we like to just leave that at the discretion of the intended parents, and it's just important that the surrogate is on the same page and that she agrees to leave that option up to the parents, whether there will be contact or potentially zero contact. It just depends on the people. When it comes to health insurance, we discussed this too, but it's just a very, very big topic, because not only do you want to make sure the surrogate has health insurance that's going to cover the surrogacy, pregnancy, and delivery, but the new law is also going to require the parents to pay for that attorney, for that policy, excuse me. So you're going to want to make sure that your attorney is doing an insurance review and that the policy does not have any surrogacy exclusions, so that you don't end up paying a high cost for pregnancy and delivery. So with that, I want to thank you all. So this was my first time doing it. I hope that you guys could all hear me and see the slides. And I'm glad I was able to do this with you all this evening and review some of the really big key changes that are going to take place in New York. And again, even if you don't have any questions now, but I see that some of you do, I'll take them in a second. If anyone wants to contact me directly, you can contact me at ys@surrogatesteps.com. That's ys@surrogatesteps.com. or directly at 607-229-6503. And I believe CNY is going to have my information also. So let me see. Some of you have questions, so I'm just going to take a look at your questions now. Okay, so I don't know if you guys can see this comment or not, but I'll just read it. It says, you mentioned that both the surrogate and at least one of the intended parents have to reside in New York. This is different for most, maybe all other states. Is that point a done deal here in New York? So basically, so this is just a new law. It's a requirement of New York. They want to make sure that it doesn't become international surrogacy type of deal. So I believe that that is going to stay, that they are requiring that the surrogate and at least one of the parents be a U.S. citizen or lawful permanent resident, and that they have to be a resident of New York. Some of the other variations of the bill before it passed the governor's budget were listed a different type of residency requirement that included just a 90-day requirement. So I don't know if that's something that's going to change or not, but so far we have the 6-month wait. Okay. Another question. What does it cost to get more than one egg transferred? And let me just see if I can turn, one second, if I can stop my screen here. Here we go. Actually, okay, there we go. Hopefully you guys can see me now. Okay, so what does it cost to get more than one egg transferred? So right now I can just talk about that in terms of what is standard in the industry. And the standard in the industry, in terms of from the surrogate's perspective and in terms of the gestational carrier agreement, there is no additional fee for the surrogate to have more than one egg transferred. However, under the new law in New York, it does require her to consent to a multiple embryo transfers. So if she does become pregnant with more than one fetus, so if she's carrying twins, for example, then there is an additional fee that she typically would be paid in the compensation, and it's typically an additional $5,000. Okay, I think that's all the questions for now. So again, if you guys have any questions for me, feel free to reach out. And to reach out to me again at ys@surrogatesteps.com or 607-229-6503. And I hope to do this with you all soon. And I hope you all got some good information that you needed. And again, I'm happy to answer any additional questions offline as well.